So, very good evening, friends. Today we will be discussing with this fresh start process. Now there are two similar processes. यहाँ पर क्या है, ये fresh start process है, एक होता है fast track. Sometimes there is a confusion कि भाई fast track कौन सा है और fresh start कौन सा है. Fresh start का मतलब ये है कि someone with meager resources, and the law also wants that such person should be discharged of their liabilities. Maybe due to some system error, they have entered this scene, but they don't deserve to be here. They don't belong to this scene. So in case of fresh start process, which covers sections 80 to 93, and which is covered in part 3 of IBC, the eligibility is a debtor unable to pay his debts and fulfill the conditions. So who can make an application? A debtor. Who cannot make an application? A creditor. So a debtor who is unable to pay his debts and fulfills the conditions specified under subsection 2 of section 82 is entitled to make an application. How he can make an application? He can make an application either personally or through resolution professional for a fresh start for discharge of his qualifying debt. So what is covered is qualifying debt, not all the debts. So in this, lot of things are there. First of all, debtor is making the application. He is unable to pay the debts and he fulfills certain conditions regarding income, assets, etc. And he can make an application either personally or through resolution professional for a fresh start or discharge of his qualifying debt. So these are the conditions. And what are the conditions for discharge of his qualifying debt? The gross annual income of the debtor does not exceed 60,000. Now, how you will calculate this gross annual income? This gross annual income you will calculate on accrual basis. Because there are questions asked in the exam that, okay, he was having this much salary, but he received this much. Or there were certain deductions from his salary. So the word is gross. It is not net. The gross annual income of the debtor does not exceed 60,000. The aggregate value of the assets of the debtor does not exceed 20,000. And there can be questions on this assets also. Suppose some of the assets are under dispute. So whether those disputed assets will be covered here or not. Suppose somebody is having a house, but that house is under litigation. There is some civil suit going on against that house regarding the ownership. So whether such assets will be covered or not, that also we will see. And the aggregate value of the qualifying debts does not exceed 35,000. So these are the conditions. The word used is aggregate value of the qualifying debts, not the aggregate value of total debts. So the word qualifying is also important. And he is not an undischarged bankrupt. So if a debtor who fulfills all these conditions, he is eligible for fresh start. And because chapter 3, this part 3 applies to individuals and partnership firms, so both individuals as well as partnership firms are covered. Because unless we discuss, we will discuss for 10-15 minutes, then we'll move on to case study. He doesn't own a dwelling unit, irrespective of whether it is encumbered or not. So he should not own a house also. But if a house is under litigation, whether it will be covered or not, that we have to see. But whether you have availed any loan or not, so you should not own a house. If you own a house, then you are not eligible for fresh start. And a fresh start process, insolvency resolution process or bankruptcy process is not subsisting against him. So if some process is already going on, some fresh start process or insolvency resolution process or bankruptcy process, then also you are not eligible. and no previous fresh start order under this chapter has been made in relation to him in the preceding 12 months of the date of application for fresh start. Suppose you made an application, say 6 months back, and that application has not yet been decided. So it says no previous fresh start order under this chapter has been made. So the word used is no previous fresh start order in the preceding 12 months. So neither a proceeding should be pending nor some order. Next is, so how is the process running? Debtor is unable to pay the debts. So he is eligibility for fresh start process. We have to check based on the conditions of this and gross annual income, aggregate value of assets, aggregate value for qualifying debts. Then we check once we check the eligibility, then an application has to be made to adjudicating authority, and it has to be supported by an affidavit regarding these conditions that, okay, I am having this much income, etc., etc. Now, once you apply, the date you apply, interim moratorium will start. So there are two moratorium here in case of individuals and partnership firms. One is the interim moratorium, which runs from the date of application. Application means date of filing, complete application. And second is the date of admission. And this application for fresh start can be moved either personally or through a resolution. Then RP will be appointed, and RP will examine the application, and he will submit the report to adjudicating authority recommending acceptance or rejection. So here, unlike CIRP, in case of CIRP, the applicant simply files the application and the adjudicating authority either admits or rejects the application. So there is no concept of recommendation there. But here, in case of individuals and partnership firms, there is a concept of recommendation. Why? Because the amount of default is very low. So there is a probability that lot of applications will come in this case once all the regulations, rules come into force. Presently, we are having this only personal guarantors to corporate debtors under this, but rest of the applications are not yet in force. So, but they have made this RP as an interim judge. So RP will examine the application and he will submit the report to adjudicating authority, and he will recommend acceptance or rejection. And based on this acceptance or rejection, normally the adjudicating authority will admit or reject the application. And he sends copy of the report of the debtor, whether debtor is qualifying for all the conditions, etc., etc. Order of adjudicating authority may be either admission or rejection of application. If it is admitted, then interim moratorium will end and moratorium will start. And it states the amounts accepted as qualifying debts or other amount eligible for discharge for fresh start. And in case they may reject also the application. Now, suppose an application has been rejected. So within 10 days, the applicant may file the objections with the RP, because the RP is the person who recommended acceptance or rejection of the application. Then RP will again have a look at the application. He will investigate and he will either accept or reject the objection. But now suppose this applicant is not satisfied by the action of the RP, then the debtor or creditor who is involved, he may challenge this acceptance or rejection. Suppose some application is accepted. In that case, who will object? Normally the creditor will object. So challenge can be done by the debtor or creditor, and he will apply to the adjudicating authority within 14 days. And then order of adjudicating authority on this objection. So in the result, application may either be accepted or rejected. And if application is accepted, which was earlier rejected, then The order will be forwarded to the board also, and board may take action against RP that, okay, RP did not fulfill his responsibilities properly. He rejected the application. However, the application was liable to be admitted. Now let us start this process. Section 78. Section 78 is basically the application of this provision. This is contained in part 3. And it says, 78 says that this part shall apply to matters relating to fresh start, insolvency and bankruptcy of individuals and partnership firms, where the amount of default is not less than 1,000 rupees. So 1,000 rupees or more is the minimum default. As in section 4, we have seen the minimum default is 1 crore and above. But here, the minimum default is not less than 1,000 rupees, and the central government may specify the minimum default, which will not be more than 1 lakh. This is the minimum. Maximum could be anything. 79. 79 talks of definitions. The adjudicating authority means the DRT. In case of corporates, which is covered in part 2, the adjudicating authority is the NCLT. But here, the adjudicating authority is Debt Recovery Tribunal for individuals and partnerships. Associate of the debtor. As in case of part 2, there is a concept of a related party. So here, there is a concept of associate also, associate of the debtor. So associate of the debtor means a person who belongs to the immediate family of the debtor, a person who is a relative of the debtor or a relative of the spouse of the debtor. So there is a concept of immediate family and then relative, and a person who is in partnership with the debtor. A person who is a spouse or relative of any person with whom the debtor is in partnership. A person who is employer of the debtor or employee of the debtor. A person who is trustee of a trust in which the beneficiaries of the trust include a debtor, or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the debtor. And a company where the debtor or the debtor along with his associates own more than 50% of the share capital of the company or control the appointment of the board of directors of the company. And for this subsection, relative with reference to any person means anyone who is relative to another. If they are members of HUF, then one person is related to the other in such manner as may be prescribed. So rules will prescribe the who is related. And section 524A we have already seen. In section 524A, related party in relation to an individual means a person who is a relative of the individual or a relative of the spouse of the individual, partner of LLP or LLP or partnership firm in which the individual is a partner. We have all seen these things. And this is the definition of relative. Husband, wife, father, mother, son, daughter, etc., etc. I think we can skip this because it is more related to individual insolvency and bankruptcy, not to fresh start. An important definition here is of excluded assets. So excluded assets for the purpose of this part includes unencumbered tools, books, vehicles and other equipment as are necessary to the debtor or the bankrupt for his personal use or for the purpose of his employment, business or vocation. Unencumbered means on which no loan has been taken, no charge has been created. So any unencumbered tools, books, vehicles and other equipment as are necessary to the debtor or the bankrupt for his personal use or for the purpose of his employment, business or vocation are excluded. So car is excluded. It could be either for personal use or for the purpose of employment, business or vocation. Unencumbered furniture, household equipment and provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his family. Any unencumbered personal ornaments of such value as may be prescribed of the debtor or his family, immediate family, which cannot be parted with in accordance with the religious usage. So 1 lakh is the limit for this. Any unencumbered life insurance policy. So the word unencumbered is used for with every asset. So if you have taken a loan, then it is not excluded. Unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. Urban area 20 lakhs, rural area 10 lakhs. Excluded debt. A liability to pay fine, but there are certain debts which are not excluded because this application for fresh start can be made only in respect of qualifying debts, and the order of discharge will also be against the qualifying debts. And what are qualifying debts? Total debts minus excluded debts. And what is excluded debt? Liability to pay fine imposed by a court, liability to pay damages for negligence, nuisance, breach of a statutory, contractual or other legal obligation, liability to pay maintenance to any person, liability in relation to a student loan, any other debt as may be prescribed. And qualifying debt. Qualifying debt means amount due, which includes interest or any other sum due in respect of the amount. And excluded, and does not include an excluded debt. This qualifying debt does not include an excluded debt. And a debt to the extent it is secured, because it is talking of encumbered. So only unencumbered. And any debt which has been incurred 3 months prior to the date of application for fresh start process. Suppose you just to take advantage of this, you incur a debt. So that debt will also be not covered. Any debt which has been incurred 3 months prior to the date of the application for fresh start process. So the timing of the debt also is important. Now let us see this fresh start process. So a debtor unable to pay, we have already seen.
Sir, 1 minute, sir. Sir,
Yes,
what is actionable assets?
Actionable assets.
What is that? Actionable claims. Actionable claims, sir.
So where it is written, in which section?
It is okay. I will see it. I will tell, sir. Okay. Somewhere it is there. I will tell.
Okay.
I
think you can refer to section 3 or section 5. You will find the definition.
No, 5 it is not there, sir. But in the other sections it is there. I will tell.
Okay.
In the course of.
So in this gross annual income doesn't exceed 60,000. Aggregate value of assets does not exceed 20,000. And qualifying debt does not exceed 35,000. He doesn't own a dwelling unit, irrespective of whether it is encumbered or not. This we have already seen. Now during this moratorium, because once you file an application for fresh start, interim moratorium will start. And during this interim moratorium, any legal action or legal proceeding pending in respect of any of his debts shall be deemed to have stayed. And no creditor shall initiate any legal action or proceeding in respect of such debt. Application has to be accompanied by affidavit, fees, etc. And application will contain the following information supported by an affidavit. So he will first of all make a list of all the debts owed by the debtor as on the date of the said application, along with details relating to the amount of each debt, interest payable thereon, and the names of the creditors to whom each debt is owed, the interest payable on the debts and the rate thereof stipulated in the contract, list of security held in respect of any of the debts, the financial information of the debtor and his immediate family. We have seen the definition of family for up to 2 years prior to the date of application. The particulars of the debtor's personal details, reasons for making the application, particulars of any legal proceedings which to the debtor's knowledge has been commenced against him, and the confirmation that no previous fresh start order under this chapter has been made in respect of the qualifying debts of the debtor in the preceding 12 months of the date of application. So no previous fresh start and no subsisting application for fresh start or CIRP, etc. Then section 82, it talks of appointment of RP. So where an application under section 80 is filed by the debtor through a resolution professional, because there are 2 scenarios. The application by the debtor may be filed on its own or through a resolution professional. So section 82 talks of the scenario where the application is filed by the debtor through a RP. So adjudicating authority will direct the board within 7 days to seek confirmation whether there are any disciplinary proceedings or not. And the board shall communicate to the adjudicating authority in either confirmation of the appointment or rejection of the appointment of the RP. So the first thing to be done on receipt of application is confirmation of the appointment of the RP. And then 82.3 talks of a scenario where an application is filed by the debtor himself and not through the RP. The adjudicating authority shall direct the board within 7 days of the date of the receipt of application to nominate a resolution professional. So in either case, a resolution professional has to be appointed, whether or not the application is made through RP. In case application is made through RP, then the adjudicating authority will confirm from the board that there are no disciplinary proceedings. And in case application has been made by the debtor himself, then adjudicating authority will direct the board to nominate a RP. Because it is based on the RP's report that the adjudicating authority is taking action. The board shall nominate a resolution professional within 10 days and the adjudicating authority will appoint the RP. And this RP appointed under this subsection 5 shall be provided a copy of the application for fresh start, because in this case the RP has not been appointed by the debtor. So RP doesn't have a copy of the application. So in case application was filed by the debtor himself and this RP is appointed by the adjudicating authority on the recommendations of the board, then RP will be provided a copy of the application because he has to examine the application. Basically, examination and whether it is fit for acceptance or rejection is to be done by the RP. But in case of CIRP, we have seen that it is to be done by the adjudicating. So section 83 says that examination of application by RP. The resolution professional shall examine the application made under section 80 within 10 days of his appointment. So 10 days are there for him to examine the application, and then he will submit a report to the adjudicating authority, either recommending acceptance or rejection. Because what he has to see? He has to see whether the debtor fulfills all the conditions regarding income, assets, debts, etc., whether any fresh start process. So all these documents will be examined by the RP and within a time bound period of 10 days. And the report referred to in subsection 1 shall contain the details of the amounts mentioned in the application, which in the opinion of the resolution professional are qualifying debts. So what he has to see? He has to see what are the qualifying debts, because a discharge order is made only in respect of qualifying debts. And fresh start process means that as regards the qualifying debts, the debtor is no longer required to make any payment because he is a man with bigger resources. And liability is eligible for discharge under subsection 3 of section 90. The RP may call for such other information or explanation in connection with the application. Now he may ask either the debtor or any other person who in the opinion of the RP may provide such information. Who could be some other person? Like in case of partnership, suppose it is a partnership firm and the application has been made by the firm, then he may ask the partners, he may ask the associates, he may ask the relatives, who in the opinion of the RP may provide such information. The debtor or any other person, as the case may be, shall furnish. So it is obligatory on such other person to furnish the information or explanation within 7 days of the receipt of the request. And the RP shall presume that the debtor is unable to pay his debts at the date of application if, in his opinion, the information supplied in the application indicates that the debtor is unable to pay his debts and he has no reason to believe that the information supplied is incorrect or incomplete. So first of all, he will presume that the RP is unable to pay the debts unless he has got some reasons to believe that the information is incorrect or incomplete. So normally he will assume that whatever is stated in the application is correct unless he has reasons. And he has reasons to believe that there is no change in the financial circumstances of the debtor since the date of the application, enabling the debtor to pay his debts. And then he has to see that there is no change in the financial circumstances of the debtor. Because when the application was made, he was an unemployed person, but now he has got a job. So if there is a change in financial circumstances, which changes financial position, then the application may be rejected. So, but there should be reasons to believe. The resolution professional shall reject the application if in his opinion the debtor does not satisfy the conditions. Conditions we have already seen, 60, 20, 35. Or the debts disclosed in the application by the debtor are not qualifying debts. Qualifying debts also we have seen. Or the debtor has deliberately made a false representation or omission in the application or with respect to the documents or information submitted. So these are the circumstances in which the RP may reject the application. And the resolution professional shall record the reasons for recommending the acceptance or rejection of the application in the report to the adjudicating authority under subsection 1 and shall give a copy of the report to the debtor. So he will record the reasons also for recommending the acceptance or rejection. So in both cases, he has to record the reasons in the report to the adjudicating authority, which is required to give within 10 days. And shall give a copy of the report to the debtor. And debtor also, because debtor is the one who has made the application. So he will give a copy of the report to the debtor. Why? Because the debtor may like to see the report and may like to challenge it. 84. Admission or rejection of the application by adjudicating authority. So adjudicating authority may, within 14 days from the date of submission of the report. So it may pass an order either admitting or rejecting the application. And the order passed under subsection 1, accepting the application, shall state the amount which has been accepted as qualifying debts by the resolution professional and other amounts eligible for discharge order under section 92. And a copy, along with the copy of the application, shall be provided to the creditors mentioned in the application. Because we have seen that the debtor is to give a complete list of the creditors. The application shall contain a list of all debts owed by the creditor, along with details relating to the amount of each debt, interest payable on, and the names of the creditors to whom each debt is owed. So all these details are provided by the debtor. So a copy will be provided to the creditors mentioned in the application, because creditors might want to object against the admission of application, because once an application is admitted under fresh start, so it may also mean that he will be absolved of all the liabilities which the creditors might object. So the creditors are also provided with a copy of the order. Effect of admission. Now, once this application is admitted, moratorium will commence. Yeah, yes, Vishwanath Patilji, please.
Sir, if there are private creditors,
They are normally private only.
and if the government, if the AA say that this has been written off, then what will be the fate of the private creditors?
No. Then he doesn't have any right.
So it is gone.
Yes, it is gone. Because actually, just see what is gone. Qualifying debts are only 35,000. So maximum what can go is 35,000.
Yeah, but whatever it is private financier.
No, that is true.
At the cost of.
But he will see, na. Actually, he will see what are the circumstances, because he otherwise also doesn't have any income. He doesn't have any assets. So even if he goes to a civil court, what he will get? So, but the adjudicating authority ensures that this applicant is genuine. So if a person is, and even government might think of
giving some relief
invoking these sections.
Okay.
So for say exempting agricultural farmers or some people who have obtained credit from this microfinancing companies or private lenders, money lenders.
Sir, what is the benefit of this fresh start process? For
benefit क्या है?
benefit debtors.
बेनिफिट देखिए प्रबरी महतो जी क्या है, कोई भूखा नंगा है उसको बोलते यार मौज कर तू, तुझे कुछ नहीं देना किसी का, बस यही है, यही बेनिफिट.
Debt is only 35,000. 35,000 मुकुब करके क्या फायदा होगा?
नहीं फायदा क्यों नहीं होगा? अब वो अदरवाइज उसको कहीं सिविल कोर्ट में ले जाएगा, ये करेगा वो करेगा, भाई उसकी जान बख्शो ना, उसको छोड़ दो।
But microfinance,
ऐसा है ना, इसमें क्या है, इट
आईपी का
गेट्स द
पीछे तो बहुत
स्टैम्प ऑफ द
पैसा चला
एडजुडिकेटिंग अथॉरिटी,
जाएगा।
दैट इज डिस्चार्ज
उसका
ऑफ हिज
उसका
लायबिलिटी।
फायदा करने के लिए आईपी का पीछे तो बहुत पैसा चला जाएगा।
कैसा?
आईपी का पीछे बहुत तो एक्सपेंसेस हो जाएगा ना।
क्यों एक्सपेंसेस? कोई फ्री में भी तो कर सकता है किसी का काम।
like,
बस सपोज देयर इज अ मेड सर्वेंट, ठीक है ना, नाउ शी हैज ऑब्टेन्ड लोन फ्रॉम ए प्राइवेट लेंडर, है कि नहीं? तो अब दैट प्राइवेट लेंडर इज आफ्टर हर, तो शी में मूव एन एप्लीकेशन। अब उसका जो हाउस ओनर है वही आईपी है, वो आईपी बोलता है अरे तुम्हें कोई चिंता करने का जरूरत नहीं, मैं तो खुद आईपी हूं, मैं एप्लीकेशन मूव कर दूंगा।
IP will render the service without taking any fees.
कर सकता है, क्यों नहीं कर सकता? वी डू सो
अच्छा,
मेनी थिंग्स फ्री ऑफ कॉस्ट, ऐसा कोई जरूरी थोड़ी है, क्यों नहीं कर सकता?
अच्छा।
भाई कोई जरूरी थोड़ी है पैसे लेना, जरूरी है? आप इतनी आईटीआर भरते हो, फ्री में नहीं भर देते कहीं होगी?
और अब आपका नोट में देखा है एक जगह में बोला जे डेटर्स does not have any dwelling house, और एक जगह में देखा जे the dwelling house in rural area
नहीं
10 lakh।
देखिए ऐसा है ना, एक्चुअली
हाँ,
वो जो डेटर डजंट हैव ए ड्वेलिंग हाउस, दैट इज द कंडीशंस, वन ऑफ द
Condition.
कंडीशंस फॉर फ्रेश स्टार्ट।
ओके।
बट वो जो
Okay.
बाद वाले लिखा है ना, दैट इज फॉर इंडिविजुअल्स एंड पार्टनरशिप फर्म्स, वो दे आर सब्जेक्टेड टू इंसॉल्वेंसी एंड बैंक्रप्सी आल्सो। नो, वी आर डिस्कसिंग ओनली फ्रेश स्टार्ट टुडे।
Okay.
but this could be detrimental to microfinance institutions, sir.
नहीं नहीं नहीं, ऐसा क्या है, इतने
Because most of their loans are small loans only, and for economically weaker people only. If all of them opt for fresh start process, then what will be the fate of microfinance institution?
नो एक्चुअली भाई ऐसा है ना, it is not that suppose somebody is genuinely not able to pay. So this
Genuine-
provision is basically for those who are not because microfinance lenders, microfinance institutions, they will also see the capability to pay, the capacity to pay. So if they have lent without seeing the capacity to pay, so there could be a threat to that.
Correct, sir.
Because they will also see, na? And normally they charge so much rate of interest also. So they
ये
presume
35
that there is bound to be some default. So that is inbuilt in their costing.
और सर 35,000 ये डिस्चार्ज करने के लिए 6 month time is a very long period.
नहीं
6
देखिए
month
ऐसा
time,
है, let
180
us
days.
not go to the logic behind all this, because I think it is a provision which basically the government has kept to invoke, to give support to the marginal people. Say
Okay.
some mine workers are there, some bonded laborers are there who have got stuck into this debt trap. So maybe they want to take them out of this.
Small vegetable vendors and things.
Yes,
like
yes.
It's done with a social objective.
Yes. So effect of admission of application on the date of the admission and this 1,000 rupees, anybody who has got a default of 1,000, then this application can be moved and minimum amount can be increased to 1 lakh also. At present it is 1,000. So even if there is a default of 1,000 rupees, only on default this application can be moved. That we have already seen in section 78, I think. And now effect of admission of application on the date of admission. भाई देखो आपको क्या देखना है, you have to see इस पर केस स्टडी आ जाएगा, आप उस एंगल से सोचो, केस स्टडी आ जाएगा, तो इसी that is why I am taking it separately.
Stop arguing and start learning.
Yes. On the date of the admission of the application, the moratorium period shall commence in respect of all the debts. ठीक है? So in respect of all the debts, not qualifying debts only. And during the moratorium period, any pending legal action or legal proceeding shall be deemed to have been stayed. And subject to the provisions of section 86, the creditor shall not initiate any legal action or proceeding in respect of any debt. And during the moratorium period, the debtor will not act as director of any company or directly or indirectly take part in or be concerned in the promotion, formation or management of a company. अब बोलेगा वो तो भूखा नंगा है, उसको डायरेक्टर क्यों बना रहे हो, या डायरेक्टर कैसे बन जाएगा? भाई कई बार पीएन को भी डायरेक्टर बना देते हैं लोग, बनाते नहीं है? जो पीएन है, मेड सर्वेंट है, सर्वेंट्स है, उनको बना देते हैं डायरेक्टर, फंसेगा तो ये फंसेगा, है कि नहीं? तो उसके लिए दे दिया कि भाई आप जो है विल नॉट एक्ट एज डायरेक्टर in a company or directly or indirectly take part and or be concerned in the promotion.
वो तो फेक कंपनी में होता है सर, डायरेक्टर।
हाँ हाँ बिल्कुल बिल्कुल बिल्कुल। तो ऐसा ना, लॉ टेक्स केयर ऑफ एवरीथिंग ना।
राइट।
तो he will not act as director of any company or directly or indirectly take part and concerned in the promotion, formation or management of a company. He will not dispose of or alienate any of his assets. He will inform his business partner that he is undergoing a fresh start process because it is applicable to partnership firms also, and be required to inform prior to entering into any financial or commercial transactions of such value as may be notified. This value is 1 lakh rupees. Disclose the names under which he enters into business transactions if it is different from the name in the application. Suppose he is entering into an agreement in some other name, है ना? Suppose he has formed a proprietorship or partnership, and if it is different from the name in the application admitted under section 84, then also he is during this moratorium, he will be required to inform. He cannot travel overseas except with the permission of the adjudicating authority, and the moratorium ceases to have effect at the end of the period of 180 days, beginning with the date of admission, unless the order admitting the application is revoked. 86 talks of objections by creditors, because once this application is admitted, there is every likelihood that they will be discharged of all the liabilities. So whenever an application is admitted, the adjudicating authority also informs the creditors. So any creditor mentioned in the order of the adjudicating authority under section 84, to whom a qualifying debt is owed, may, within a period of 10 days from the date of receipt of the order, object only on the following grounds. First, inclusion of a debt as a qualifying debt. So you may say that okay, this is not a qualifying debt. We have already seen the definition of qualifying debt. Or incorrectness of the details of the qualifying debt. That okay, my debt was more, he has included less. A creditor may file an objection under subsection 1 by way of an application to the RP. So in this case also, the application has to be moved through RP. So RP is the Pandit in this case. Debtor भी जाएगा तो भी RP के through जाएगा. Although he may apply individually to the adjudicating authority, but then also the adjudicating authority will appoint the RP and he will be examining the application. In case the objection is there, then creditor will also file an objection to the RP, because RP is the person who knows all the facts. He is the person who had recommended the acceptance or rejection of the application.
Same RP, sir?
Huh?
Creditor will have to go to the same RP?
Definitely. Yes, yes.
Yeah, not some other, through some other RP.
Naturally, because he is filing an objection. No? So a creditor may file an objection by way of an application to the RP. Naturally. The application under subsection 2 shall be supported by such information and documents as may be prescribed. And the RP will consider every objection made under this section, and RP will examine the objections and either accept or reject the objections within 10 days of the application. So for within 10 days, he has to move the application. Within 10 days, the creditor has to file an objection, and within 10 days, the RP will examine the objections and he will either accept or reject the objections within 10 days. And RP may examine on any matter that appears to him to be relevant to the making of a final list of qualifying debts. And on the basis of examination, the RP will prepare an amended list of qualifying debts, make an application to the adjudicating authority for directions, or he will take any other steps in relation to the debtor. Now, application against a decision of the RP. Now, suppose either the RP rejected or accepted the application. In case the application was rejected or the recommendation was of rejecting the application, then the debtor may move an application. And in case the recommendation was for accepting the application and the creditor moved an objection and the RP rejected the objection. So in both the cases, the debtor or the creditor who is aggrieved, debtor will be aggrieved in case application is rejected. Creditor will be aggrieved in case application is accepted or his objection is not entertained. So the debtor or the creditor who is aggrieved by the action taken by the RP may within 10 days of such decision. So 10 make an application 10 days for the RP to recommend acceptance or rejection. Then 10 days by the creditor to move an objection, 10 days by the RP to consider the objection, and 10 days to make an application against decision on the following grounds. Namely, first, that the resolution professional has not given an opportunity to the debtor or the creditor to make a representation, or that the RP colluded with the other party in arriving at the decision, or that the RP has not complied with the provisions of section 86. And the adjudicating authority shall decide the application referred to subsection 1 within 14 days. And where the application under subsection 1 has been allowed by the adjudicating authority, it shall forward it to the board, and the board may take such action as may be required under chapter 6 of part 4 against the RP. Because in this case, RP did not fulfill his responsibility properly. Either he recommended acceptance when the application ought not to have been accepted, or he rejected the application when the application ought to have been accepted. He did not consider the objection by the creditor, but he should have considered it. So in all such cases, the A will forward a copy of the order to the board, and the board may take action against the RP. 88. Then it talks of general duties of the debtor. The debtor will make available to the RP all information relating to his affairs. He will attend meetings and comply with the requests of the resolution professional in relation to the fresh start process. He will inform the RP as soon as reasonably possible of any material error or omission in relation to the information or documents supplied to the RP, or any change in the financial circumstances after the date of application. Maybe he got some money, maybe he got employment, where such change has an impact on the fresh start process. Impact means that either of the conditions have changed. Then 89 talks of replacement of the RP. So where the debtor or the creditor is of the opinion that the RP is required to be replaced, he may apply to the adjudicating authority for replacement. And the adjudicating authority within 10 days will make a reference to the board. Board within 10 days will revert, and it will recommend the name of the RP, and then the adjudicating authority will appoint another RP. The adjudicating authority may give directions to the RP replaced under subsection 4 to share all information with the new RP, because earlier some other RP was there, now new RP is there. So the old RP will share the information with the new RP and to cooperate with the new RP in such manner.
Then 7 days है 10 days है
कहाँ पर
ये जो आपने पढ़ा जो एप्लीकेशन रिप्लेसमेंट की है 10 दिन है 7 दिन है
सेक्शन 89 की बात कर रहे हैं
89.2 सर
हाँ 89 में ऐसा ना 7 दिन के अंदर जो है एडजुडिकेटिंग अथॉरिटी बोर्ड से पूछेगा और बोर्ड रिवर्ट करेगा 10 दिन के अंदर।
अच्छा
ये ना जी, बट फिर भी आप ऐसा है कई बार गलती भी हो सकती है, तो आप इसको उससे मिला लीजिएगा कि एक बार टैली कर लीजिएगा। वैसे वही है 7 और 10 ही है। इन द बुक आल्सो इट इज 7 and 10। हाँ जी
ठीक है सर।
The adjudicating authority shall appoint, हो गया सारा। Directions for compliance of restrictions. So RP may apply to the adjudicating authority for any of the following directions, namely compliance of any restrictions referred to in subsection 3 of section 85। भाई वो बाहर जा रहा है कहीं, ठीक है ना, हमने बता देना वो डायरेक्टर नहीं बन सकता, बाहर नहीं जा सकता। So if any of compliance or restrictions जो है which have been placed on the debtor, so he may apply to the adjudicating authority. And compliance of the duties of the debtor referred to in section 88 in case of non-compliance. So in 88 some duties have been cast upon the debtor, ठीक है ना भाई, he will make available all information etc. तो ये सारा जो है इसके लिए वो he can make an application to the adjudicating authority. The RP may apply to the adjudicating authority for directions in relation to any other matter. 91 is revocation of order admitting the application. Now suppose an application has been admitted, ठीक है, but RP later on thinks that this application should not have been admitted, So the RP will submit an application to the adjudicating authority seeking revocation of its order made under section 84 on the following grounds, namely, if due to any change in the financial circumstances of the debtor, the debtor is ineligible for a fresh start process. Maybe he was earlier unemployed, now he is in gainful employment. Non-compliance of the debtor of the restrictions, okay, traveling overseas, becoming a director, etc. If the debtor has acted in a malafide manner and has willfully failed to comply with any of the provisions. So adjudicating authority within 14 days, it may by order admit or reject such application of the RP. On passing of the order admitting the application, the moratorium and fresh start process shall cease to have effect, and a copy of the order will be provided to the board for the purpose of recording an entry in the register referred to in section 196. Then 92, discharge order. The resolution professional. Basically, the RP is doing all the work and the adjudicating authority is just putting a stamp of approval on it. The RP will prepare a final list of qualifying debts and submits such list to the adjudicating authority at least 7 days before the moratorium period comes to an end. है ना? Moratorium is 180 days, I think. है ना? कितना है period इसमें? 180 days है ना? ये हमने पढ़ा था यहाँ थोड़ा पहले जो moratorium लिखा था.
Yes, sir, 180 days.
हाँ
180 days.
हाँ. The RP will prepare a final list of qualifying debts and submit such list to the adjudicating authority at least 7 days before the moratorium period comes to an end, and the adjudicating authority shall pass a discharge order at the end of the moratorium period for discharge of the debtor from the qualifying debts. क्योंकि क्या होता है? From which debts he is discharged, it is written in the order itself. And without prejudice to the provisions of section 2, the adjudicating authority shall discharge the debtor from the following liabilities, namely penalties in respect of the qualifying debt from the date of application till the date of the discharge order, interest including penal interest from the date of application till the date of discharge order, and any other sums owed under any contract in respect of the qualifying debts from the date of application till the date of the discharge order. Because this statement regarding qualifying debts, qualifying assets, वगैरह, it was made as on the date of application. But suppose some interest, some penalty has occurred during this period from the date of application till the date of discharge order. So that also may be discharged. The debtor may be discharged from the following liabilities also. Discharge order shall not discharge the debtor from any debt not included in subsection 2 and from any liability not included in under subsection 3. So whatever is written in the order is final. Suppose something is not written, suppose some debt is not mentioned, then the debtor is not discharged from that debt. Discharge order shall be forwarded to the board, and the discharge order under subsection 2 shall not discharge any other person from any liability in respect of the qualifying debt. So this discharge order will operate only against the person who is mentioned in the order. And the other person, suppose there is a co-borrower, so co-borrower will not be absolved of his liability. And the RP will perform its functions and duties in compliance with the code of conduct. So this is a brief summary. And there is a recording also. You can find a recording on my YouTube channel also regarding fresh start. So I'll share the link for that also. But now let us see a case study. Let us see this case study. Now Roshan is a 24-year-old boy living with his parents. He opened a grocery outlet to make a living, but the same had to be shut down due to continuous losses. Presently, he is not engaged in any gainful employment. So it means he doesn't have any income. Income तो कुछ है ही नहीं. ठीक है. He has incurred a liability to pay to various vendors a sum of 35,000. तो यहाँ पर भी ठीक है. भाई 3 क्राइटेरिया था, इनकम, एसेट्स और लाइबिलिटी. डेट उसके 35,000 है, इनकम उसकी 0 है. ठीक है. Room in which he is living is jointly owned by him along with his parents. However, the ownership is disputed and the case pertaining to ownership is still pending in a civil court. Now, this ownership is disputed. Ownership क्या है? Regarding the ownership, let us see the clause. क्या बोलता? Ownership कैसी होनी चाहिए? इनकम और वो वाला तो क्लियर हो गया, ठीक है ना। क्या बोलता है, ही डजंट ओन ए ड्वेलिंग यूनिट इररिस्पेक्टिव ऑफ वेदर इट इज एनकम्बर्ड और नॉट. So whether he has taken any loan or not, that is immaterial, but he should not own a dwelling unit. And where the ownership is under dispute, तो फिर तो naturally अभी तो owner नहीं है ना वो उसका. And he will give an affidavit also. And in case circumstances change, then RP will inform, or this debtor is under a liability form. ठीक है ना. तो अगर उसके circumstances change हो जाएंगे बाद में, suppose बाद में ownership उसको मिल गई, suppose he gets the ownership through an order of the court, so then he will become an owner. So in view of the above facts, please state whether he can opt for fresh start process or not. So there are three things. Number one, no income. Income तो कुछ है ही नहीं. जो liability है कितनी है, 35,000 है. 35,000 भी ठीक है. ओनरशिप की जहां तक बात है, तो ओनरशिप में क्या है, अभी डिस्प्यूटेड है. तो डिस्प्यूटेड है तो ओनरशिप तो मानी नहीं जाएगी ना उसकी, ठीक है ना. द ऑर्डर में बी अगेंस्ट और फॉर हिम. अगर सपोज भाई ऐसा है, फॉर द सेक ऑफ आर्गुमेंट वी से दैट ओके दिस ओनरशिप इज डिसाइडेड इन हिज फेवर, देन हिज सर्कमस्टांसेस विल चेंज, है ना. एंड ही विल इन्फॉर्म द आरपी ऑफ द चेंज्ड सर्कमस्टांसेस, देन ही मे कम आउट ऑफ दिस.
Okay, sir.
And next is, would your answer be different in case they win the suit regarding ownership? So I have already answered. So in case they win the suit, naturally, he will come out of this.
Sir, questions are not on the screen.
Okay, sir.
Which question?
Case study only facts are there.
नहीं, अभी question तो बनाया नहीं ना.
Okay, okay.
अभी this halwa is still under preparation.
Okay.
So as soon as it is ready, it will be served hot.
Yes, sir.
Next. Now Rita is a nurse working in CMC Chennai. But questions तो आपको बता तो दिया ना, वही यही है, उसी को बना देंगे, अभी टाइम नहीं मिला थोड़ा. Rita is a nurse working in CMC Chennai. She had graduated in nursing from CMC Ludhiana.
हेलो
Since her-
सर, 1 minute.
Yes, yes.
रोशन वाला का आंसर क्या है?
किसका आंसर?
रोशन
देखो
The
जी, ऐसा
previous
है,
question.
आंसर तो यही है कि प्लीज स्टेट वेदर ही कैन ऑप्ट फॉर फ्रेश स्टार्ट प्रोसेस. ये यहाँ
Right.
यहीं पर
He
लिख
will
देता
be
हूँ.
he is eligible for fresh start process.
बिल्कुल बिल्कुल एलिजिबल है.
Right.
और दूसरा क्या बोलता है, वुड योर आंसर बी डिफरेंट इन केस दे विन द सूट? यस, आंसर तो डिफरेंट हो जाएगा ना. इन दैट केस ही विल नॉट बी
Then
एलिजिबल.
he will be disqualified.
यस यस यस.
Yeah. Okay.
मैं यही लिख देता हूँ. अरे सर, रिकॉर्डिंग तो मिल जाता है, और बच्चे की जान लोगे क्या आप? रिकॉर्डिंग में सब मिलता है. चलो अगला देखते हैं. हाँ जी, ये क्या है, रीटा इज ए नर्स वर्किंग इन सीएमसी चेन्नई. ठीक है. शी हैड ग्रेजुएटेड इन नर्सिंग फ्रॉम सीएमसी लुधियाना. Since her mother was not keeping in good health, she left her job and shifted to her ancestral village in Palakkad to take care of her ailing mother. The owner of the medical shop is very kind and allows her to purchase medicines on credit. भाई ठीक है, तुम्हारी मदर बीमार है, आप उधार लेते रहो, हमसे कोई दिक्कत नहीं. Till date, the outstanding dues to the medical shop owner are 1,20,000. अब देखो यहीं पर ही जो है वो हो जाना चाहिए. आउटस्टैंडिंग ड्यूज कितने हो गए? 1,20,000. To clear these dues, she took a loan of 30,000. Her mother gifted the jewelry which she had got on the occasion of her marriage to Rita. अब ये कि ये जो excluded assets हैं, अब इन excluded assets, how much ornaments कितने हैं वो? Up to 1 lakh rupees. Besides this, Rita owns an old Maruti car as well. ठीक है. तो अब ये जो ओल्ड मारुति कार है, मारुति कार में क्या है, हमने क्या पढ़ा था उसके बारे में एक्सक्लूडेड एसेट्स में, कि व्हीकल व्हिच इज यूज्ड फॉर पर्सनल यूज और फॉर ऑक्यूपेशन, दैट इज आल्सो एक्सक्लूडेड. ठीक है. और ये जो ज्वेलरी है, ज्वेलरी में क्या हो गया, ज्वेलरी इसको ओकेजन ऑफ मैरिज पर मिली, में भी मंगलसूत्र समथिंग, तो वो जो है दैट इज आल्सो एग्जेम्प्ट. ठीक है. अब ये लोन जो है, लोन ऑफ 30,000 इज आल्सो एग्जेम्प्ट. बट ये जो आउटस्टैंडिंग ड्यूज है, दिस इज अलार्मिंग सम बेल्स, कि भाई ये जो आउटस्टैंडिंग ड्यूज है ये 1,20,000, ये थोड़े ज्यादा लग रहे हैं. ठीक है ना. अच्छा, बिसाइड्स दिस शी हैज नो अदर एसेट्स. शी हैड अप्लाइड फॉर ए फ्रेश स्टार्ट प्रोसेस बट लेटर विथड्रू ड्यू टू सम रीजंस. सो इन दिस केस शी अप्लाइड फॉर ए फ्रेश स्टार्ट प्रोसेस. Now we have to see when she applied, because in case some fresh start process is already subsisting, है ना, within 1 year. So 1 year is the period for that. हम fresh start वाला भी देख लेते हैं. Let us see that section. क्या है वो section? ये 80 का F में क्या बोलता है? A fresh start process, insolvency resolution process और bankruptcy process is not subsisting against him. अभी तो कुछ है नहीं, subsisting तो है नहीं क्योंकि it has been withdrawn. ठीक है? And no previous fresh start order under this chapter has been made in relation to him in the preceding 12 months of the date of the application for fresh start. Now there could be some confusion here कि ये जो है क्या बोलता है कि no previous fresh start order has been made. अब suppose she applied for a fresh start, है ना, but she later withdrew it. Then whether some fresh start order was made or not, so that we have to see. But apparently क्या लग रहा है कि यहां से भी she is not disqualified because it is not subsisting, because the application has already been withdrawn, and supposedly no previous fresh start also has been made in relation to him in the preceding 12 months. So based on the facts, exact facts, we have to see. Suppose the facts, इसको थोड़ा सा हम tilt कर देते हैं, change कर देते हैं facts को कर देते हैं कि भाई she applied for a fresh start and that application was rejected by the adjudicating authority. So
Sir,
in that,
1 minute, sir.
the
Sir,
scenario will change.
Sir,
हाँ,
hello, sir,
हाँ,
Gupta
बोलिए.
sir. That medical shop also she has to owe 1,20,000, sir. 1,20,000 plus 30, it may
हाँ,
exceeds
हाँ,
the 35. Whether
हाँ,
she is
बिल्कुल
not
ठीक है. नहीं तो
eligible.
अभी हमने पूरा आंसर कहाँ दिया? पूरा अभी तो we are still discussing ना.
Okay, okay.
वो तो है ही. हाँ जी.
सर इसमें एक ये भी कंडीशन है ना कि डेब्ट्स incurred 3 months prior to the date of application. So maybe that 1,20,000 is more than like.
No, no,
Yes. Yes, maybe she because yes. So the debts which are 3 months they are not but then she will not be discharged of this liability, no, 1,20,000. Let us again move to that thing. What is that provision? Let us see.
Qualifying debt.
Which is the section? Section कौन सा है इसका?
79 में 19. Definition of qualifying debt.
So it says any debt which is incurred 3 months prior to the date of application for fresh start process.
But sir, amount of debt should not exceed 35,000.
हाँ हाँ नहीं वो ठीक है. वो क्या बोल रहा है भाई, क्वालिफाइंग डेट है ना, जो डिस्चार्ज ऑर्डर होगा क्वालिफाइंग डेट का होगा. इसकी ये तो क्वालिफाइंग डेट में आएगा ही नहीं ना. तो इवन इफ शी ऑब्टेन्स ए डिस्चार्ज ऑर्डर फ्रॉम एडजुडिकेटिंग अथॉरिटी, she will not be absolved of this liability. This liability she has to pay. Suppose she has incurred this liability within last 3 months, so she has to still to pay.
sir, eligibility, sir, whether she is eligible or not.
हाँ sir,
Yes.
eligibility का है ये.
हाँ
So she is not eligible for CIR. ये fresh start.
नहीं बिल्कुल एलिजिबल हो जाएगा. क्यों नहीं होगा एलिजिबल?
Eligible है sir, eligible है.
ऐसा है ना, थोड़ा चेंज कर देते हैं इसको, इसके फैक्ट थोड़े चेंज कर देते हैं. ठीक है. अब इसमें ये है जॉब इन दिसंबर 2022. ड्यूरिंग पास्ट 3 months कर देता हूं मैं इसको. ठीक है. हमने क्या कर दिया? टिल डेट द आउटस्टैंडिंग ड्यू टू द मेडिकल शॉप ओनर ड्यूरिंग द पास्ट 3 months आर ₹1,20,000. टिल डेट भी छोड़ देते हैं, इसको कर देते हैं टोटल आउटस्टैंडिंग. तो टोटल आउटस्टैंडिंग ड्यूज टू द मेडिकल शॉप ओनर ड्यूरिंग पास्ट 3 months आर 1,20,000। अब वहां से बाहर निकल गई, वो 1,20,000 से भी बाहर निकल गई।
नहीं सर, it is incurred prior to are more than 3 months old, then तब वो बाहर निकलेगी ना।
नहीं 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 नहीं, वहां का ना उल्टा है, देखो।
Should not,
Sir,
does not
more than 3 months. More than, it should be more than 3 months.
3
अरे सर जी, एक कौन
Prior
सा
to
सेक्शन था?
3
79 है ना। एक मिनट एक
If it
मिनट।
is included in the 3
अरे
months,
एक
the
मिनट
date
देखो तो
will
सही
be,
सर, एक मिनट
date will be
एक मिनट
included.
यार, देखो एक प्लीज देखो क्या बोलता है क्वालिफाइंग डेट। क्वालिफाइंग डेट में ये इंक्लूडेड नहीं है, डज नॉट इंक्लूड।
हाँ,
Excludes.
यस। तो
Even
क्या है
30,000
ये वाला डेट अगर कोई पिछले 3 महीने में ले लिया, वो इंक्लूड नहीं होगा। उसका क्या लॉजिक है? उसका लॉजिक ये है कि भैया वो जानबूझ करके ऐसा कोई डेट ले ले, उसको पता है 35,000 तक तो माफ हो ही जाएगा, ले लो 35,000 रुपए तक। तो इट सेज एनी डेट विच हैज बीन इनकर्ड 3 months प्रायर टू द डेट ऑफ एप्लीकेशन।
Okay, sir.
फिर वही तो, does not include any debt which is incurred 3 months prior to the date of application.
हाँ,
So it means कि वो
नो अब ये
older
3 months प्रायर का मतलब क्या है? 3 months प्रायर का मतलब ये है कि अब आप डेट ऑफ एप्लीकेशन से उल्टा चलोगे ना। देखो 3 months आप हाउ यू विल कैलकुलेट, यू विल गो बैकवर्ड्स फ्रॉम द डेट ऑफ एप्लीकेशन। डेट ऑफ एप्लीकेशन से 3 months तक चलो, यू विल गेट द आंसर।
तो कोई क्वालिफाइंग डेट तो जीरो हो गया फिर तो,
है
अपने केस में क्वालिफाइंग डेट जीरो हो गया फिर तो।
यस, हाँ बिल्कुल बिल्कुल। तो जीरो
तो-
करने से उसको फायदा तो नहीं है ना, वो 1,20,000 तो उसको देना ही पड़ेगा।
नहीं देना पड़ेगा, बट फिर एप्लीकेशन किस चीज का वो एडमिट
सिर्फ
कराया?
35,000 है ना,
30,000 से तो छूट गई ना वो,
लोन अमाउंट है।
जो लोन अमाउंट से छूट गई ना, 30,000 से तो बरी हो गई।
लोन तो बाद में लिया ना सर, 3
कौन सा
महीने
बाद में
अगर
लिया?
आपने कह दिया आउटस्टैंडिंग 1,20,000 तो उसके बाद ही में लोन लिया, वो भी 3 महीने के बाद के उसमें आ गया। फॉर पेमेंट ऑफ दीज ड्यूज शी इनकर्ड अ लायबिलिटी, took a loan, so obviously after 3 months she took, no, within 3 months package.
नहीं पहले का चेंज करना है,
पहले वाला ही चेंज कर देते फिर इसको।
चेंज कर
आप
दो।
पहले वाला चेंज कर दिया, then it is fine.
ऐसा है ना, बाय डिस्कसिंग दीज
Case
वेरियस परम्यूटेशंस एंड
study under
कॉम्बिनेशन,
construction,
आइडिया
under
इज
construction.
टू अंडरस्टैंड द कॉन्सेप्ट,
Right, that's true,
है ना। हाँ, तो टोटल ड्यूज
is 25,000.
बस इसको पास 3 months हटा दो। अब हमने हटा दिया
डिस्क्वालीफाई हो गए,
है, हाँ
डिस्क्वालीफाई हो गए।
डिस्क्वालीफाई हो गई। हाँ, और अगर ये लिख दिया आपने तो फिर जो है ड्यूरिंग पास्ट 3 months।
RP will reject the application.
अगर
ठीक
ये
है जी।
लिख दी, if it is written, then there is no qualifying date for which she is moving the application, then it is zero in my
सर
opinion.
40,000 को पहले का ड्यूज बता दीजिए तो क्वालिफाई कर जाएगा।
किसका? हाँ हाँ हाँ,
तो पहले का ड्यूज 30,000 को पहले बता दीजिए, पहले का कोई बकाया लोन है, पेंडिंग लोन 3 साल 2 साल पहले का बता दिया जाए तो क्वालिफाई हो जाएगा वो।
नहीं ऐसा है ना भाई, एक मिनट
Sir,
इसको-
we should put,
सर मॉडल क्वेश्चन पेपर है,
हाँ
केस स्टडी है, तो उसमें ये प्रायर वाला 3 months प्रायर टू एप्लीकेशन ही है। अगर ये हम अब अपने 1,20,000 को अगर लिखिए कि इट इज प्रायर, इट इज मोर देन 3 months ओल्ड, तब ये क्वालिफाइंग डेप्थ में नहीं आएगा।
हाँ ठीक है, तो क्वालिफाइंग डेट में नहीं आए तो देखो ऐसा है,
मोर विदिन होगा 3 months का तब ना नहीं आएगा, पीछे चला जाएगा 3 महीने से पुराना तब तो आ जाएगा।
देखिए ऐसा है, आप 79 को अगर हम पढ़ते हैं, आप पढ़ो ना क्या बोलता है, एनी डेट विच इज इनकर्ड 3 months प्रायर टू द डेट ऑफ एप्लीकेशन। भाई अगर मान लो इसको 1 day होता, आप इसको ऐसे पढ़ो, एनी डेट विच इज इनकर्ड 1 day प्रायर टू द डेट ऑफ एप्लीकेशन, तो क्या मतलब समझोगे आप इसका? ऐसे 1 week प्रायर टू द डेट, तो क्या मतलब समझोगे आप? तो ऐसे ही 3 months है, आपको उल्टा चलना है, फ्रॉम द डेट ऑफ एप्लीकेशन,
अच्छा,
यही तो मतलब है ना। भाई
सर, मैं
अगर मैं इसको लिख दूं विच इज इनकर्ड से 2 days प्रायर टू द डेट ऑफ एप्लीकेशन, तो क्या मतलब समझोगे आप? यही समझोगे ना? तो 3 months में पीछे कहाँ पहुंच गए आप?
No, madam is getting confused with some model question paper, model
तो उसे
solution.
छोड़ो, क्या मॉडल में क्या लिखा है उसे छोड़ दो, मैं तो पढ़ा भी नहीं, देख लेंगे। चलो प्लीज वो उसको भी शेयर कर दीजिएगा ग्रुप में। बट इसमें बात ये है कि 3 months प्रायर टू द डेट, मेरे हिसाब से आई थिंक ऑल विल एग्री टू दिस इंटरप्रिटेशन कि प्रायर टू द डेट ऑफ एप्लीकेशन मतलब डेट ऑफ एप्लीकेशन से यू टू मूव बैकवर्ड्स,
Correct, sir. Correct.
करेक्ट सर, रियली सही सर।
है ना?
Yes, sir.
तो मैंने आपको एग्जांपल भी दे दिया, 1 day प्रायर टू, 2 days प्रायर टू, तो 2 days प्रायर 2 में दूसरा होगा और 3 months में दूसरा डेफिनेशन होगा, ऐसा तो चलेगा नहीं।
क्वेश्चन में 2 महीना कर दीजिए ना सर, क्लियर हो जाएगा।
किसको?
है ना 3 महीने का, उसको 2 महीने का कर दीजिए, तो 3 महीने के नहीं पहले का हो जाए, इधर का हो जाएगा।
अरे वो तो आप देखो, हम तो मैक्सिमम अमाउंट लेंगे, मैक्सिमम लेंगे, उसमें क्या फर्क पड़ रहा है?
हाँ जी
3 महीने
सर।
में कुछ समझने में दिक्कत थोड़ी हो रही है। 2 महीने में क्या, 2 महीने में समझ में आ रहा है, 3 महीने में समझ में नहीं आ रहा है, तो कोई बात नहीं हुई।
नहीं आप समझ में आ गया हो,
है ना? तो एनीवे वी विल डिस्कस दैट थिंग आल्सो, वो जो वहां मॉडल के स्टडी में है। देखो जी, ऐसा है अंडरस्टैंडिंग मेरे हिसाब से तो यही बनती है
ठीक है
कि
सर।
जो पास्ट 3 months है, अगर उसमें कोई ड्यूज है तो वो दैट विल नॉट बी एब्जॉर्ब्ड, दैट
Qualified.
लायबिलिटी विल नॉट बी एब्जॉर्ब्ड, वो उसको
Correct.
देना ही पड़ेगा। ठीक
Correct.
है, अब बात ये हो गई कि ये आप इसको छोड़ दो ना, टू क्लियर दिस ड्यूज, ये लिख दो शी हैज टेकन अनदर लोन, बस, और क्या, ऐसा कर दो।
हम ये कहाँ घूम रहे हैं?
अब
There
शी
is
टुक,
also one more loan.
हाँ शी टुक अनदर लोन।
And what about the job and income, sir?
इनकम तो
Monthly
दे दिया ना नीचे, 25,000 रुपए है उसका, पुराना वाला जॉब तो छोड़ दिया उसने।
हाँ,
नहीं, this job she is earning 25,000 rupees,
हाँ
ना?
25,000 का है इसका तो जॉब, ये कम है ना, ये तो। शी टुक अनदर लोन फ्रॉम ए प्राइवेट मनी लेंडर।
अर्ली इनकम तो 60,000 से अधिक हो जा रहा है इसका।
कहाँ हो रहा है?
25,000 पर मंथ है, तो ईयरली तो 60,000 से
अभी
अधिक।
1 महीने तो हुआ काम करते हुए उसको।
how much it should be, sir? Annual
धीरे से
income?
पेमेंट कर सकती है ना, she can pay
कौन सा?
gradually
रोटी
from
नहीं
her
खाएगी,
job.
अरे बेटा
30,000 रुपए देते उसको।
नहीं, not today only, by gradually she can pay ना।
30,000 लोन कब लिया?
वही तो कर रहे हैं ना, शी टुक अनदर लोन फ्रॉम ए प्राइवेट मनी लेंडर इन द मंथ ऑफ जनवरी। अभी क्या है, ये जनवरी में ले लिया, ये जनवरी 2023, जनवरी 2023, तो जनवरी में लोन लिया। तो अब बताइए कि भाई ये कर सकती है या नहीं कर सकती? अब आप देखो, ये वाला जो है ना, ये वाला ड्यूरिंग पास्ट 3 months, ये सिविल ऐसा है, वी कैन फ्रेम 10 क्वेश्चंस ऑन दिस अलोन। पहला क्वेश्चन क्या हो जाएगा कि वेदर द डिस्चार्ज ऑर्डर विल कवर द लायबिलिटी of rupees 1,20,000? The answer is no,
No.
because this liability was incurred during past 3 months. Whether this private loan will be covered? Yes, it will be covered. And whether this gift jewelry is excluded asset? Yes, it is excluded asset. Whether this Maruti car is excluded asset? Yes, it is excluded asset, because vehicle is exempted whether for personal or business use.
सर वो ज्वेलरी के लिए it is written that it should be for religious purpose.
No, that is true, but वो बोला है ना on the occasion of our marriage.
Okay.
और मैरिज में उसमें भी क्या है कि only up to 1 lakh it is exempt. अब और ये है कि she had applied for fresh start process but later withdrew, तो उसलिए उसका कोई ऑर्डर भी नहीं हुआ है, ठीक है ना, and nothing is subsisting against her, कोई पुराना बाकी भी नहीं है। So in view of this, he can apply for this fresh start process. उसमें क्या होगा, ये 30,000 से she will be absolved of this liability.
क्वालिफाइंग अमाउंट होगा 30,000।
Yes,
30,000 भी तो जनवरी का हो गया, तो ये भी तो नहीं आएगा।
क्यों?
3 महीने के अंदर का कहाँ से आएगा सर? ये जनवरी का है, 1 महीना भी नहीं।
No, that is a old loan.
22 से लिखिएगा तब आएगा।
इसको 22 कर लो,
January
हाँ,
22.
22
चलो।
देने पड़ेगा, राइट?
22 कर लो, चलो ठीक है जी। तो ऐसा है, ये क्यों अप्लाई कर रही है? शी इज अप्लाइंग बिकॉज मनी लेंडर इज प्रेशराइजिंग हर हार्ड टू
जी सर,
रीपे।
जी सर।
अब उसको महतो जी ने बता दिया, अरे कोई प्राइवेट लेंडर को देने का जरूरत नहीं, मैंने अभी अभी ये फ्रेश स्टार्ट प्रोसेस पढ़ा, गुप्ता जी ने बताया था, तो भैया तुम्हारा वो जो है शी विल बी डिस्चार्ज ऑफ दिस लायबिलिटी, मैं अप्लाई करता हूँ तुम्हारे लिए, कोई फीस भी नहीं लूंगा। और ये
जी सर।
राइट।
है
What should be the income, sir? To
इनकम
to be
35, इनकम 60,000 है ना
per month, sir?
इनकम सर तो पहले
ओ, बोलो,
annual,
बोलो।
annual।
तो कुछ भी मिलता होगा ना,
लिविंग
60,000 per
पूरा
month, sir.
फाइनेंशियल अकाउंट होगा ना सर।
हाँ हाँ हाँ
पहले जॉब छोड़ा है तो उधर पहले भी कुछ तो पेमेंट मिलता
हेलो?
होगा, क्लियर करना पड़ेगा वो भी।
हाँ, करना पड़ेगा, बिल्कुल बिल्कुल बिल्कुल।
60,000 per month or per year, sir?
पर ईयर।
Then she is getting monthly salary of 25,000.
20
हाँ, बट अभी जॉब लगा ना उसका,
नहीं, पहले भी तो आपने जॉब
तो
छोड़ा
पुराने
है,
वाला जॉब छोड़ दिया ना उसने।
तो उसमें
Told
तो
them,
मिलता
but now
होगा
she has
सर।
got her position as
20,000 मिल रहा है तो उधर 10,000 भी तो मिल रहा होगा।
भाई अब आप ये सोचो कि मान लो उसने ये, इसको थोड़ा सा और चेंज कर दो फैक्ट्स को, ठीक है?
जॉब
ये इसने
पहले वाला
क्या,
नहीं था, लिख दीजिए
इसको
ना।
क्या किया इसने, अप्रैल में छोड़ दिया, ठीक है? इन अप्रैल 2022, ठीक है?
जी, तब हो
और
जाएगा।
ये लोन ले लिया इसने जनवरी में, ये भी हो गया। और अब इसका ये वाला लोन कब लेगी है? जनवरी 22, जनवरी 21 में ले लो ये लोन, ये जनवरी 21 में ले लिया। अब ठीक है,
लास्ट 1 मंथ से मतलब कि 2 महीना हो जाएगा।
because of her new job of 25,000 salary per month.
हाँ
ठीक है सर,
She will not be
चलेगा
eligible.
चलेगा आ जाएगा सर इसमें अब।
ऐसा है, मोर फैक्ट्स विल बी देयर बट बेसिक
जी।
आइडिया यू हैव अंडरस्टूड ऑल। देखो ऐसा है, देयर आर 2-3 थिंग्स। नंबर 1, वी हैव टू सी दी एक्सक्लूडेड एसेट्स, कौन से एक्सक्लूडेड एसेट्स हैं, कौन से क्वालिफाइंग डेट्स हैं, दैट कॉन्सेप्ट्स वी हैव टू सी। मेन बात ये है, बाकी तो बेस्ड ऑन द एग्जैक्ट फैक्ट्स दिस केस स्टडी कैन बी रीफ्रेम्ड,
जी सर, जी सर।
है ना?
तो
बट बेसिक आइडिया तो हमें मिल गया ना कि भाई
नहीं, बहुत
इस तरह
अच्छा
से।
केस है सर, ये केस आपने बहुत अच्छा बनाया।
So in this case, she will not be able to get the application, right? So now,
क्यों एप्लीकेशन बना सकती है, क्यों नहीं दे सकती?
sir, 1,20,000 हो गया ना?
हाँ,
कहाँ
30,000
1,20,000 हो गया?
ओनली 30,000 आएगा क्वालिफाइंग में।
अच्छा, ठीक है, right.
1,20,000 तो आएगा नहीं ना, ये तो अभी अभी लिया ना उसने।
Excluded.
बट ये उसको देना पड़ेगा 1,20,000। अभी क्या है, अभी उसको मनी लेंडर तंग कर रहा है, अभी उसको मनी लेंडर कह रहा है मेरे पैसे दो, ये 30,000 रुपए, और वो 30,000 से छुटकारा पाना चाहती है, तो इसीलिए उसने अप्लाई कर दिया फ्रेश स्टार्ट के लिए।
तो
क्या ले
6
लो
महीने
मेरे
तक
से?
नहीं करेगा सर, 6 महीना तक नहीं करेगा, 6 महीना तक बची रहेगी ना।
नहीं 6 महीने नहीं,
एक
6
साल
महीने
के
क्यों?
लिए तो मोरेटोरियम रहेगा ना सर।
नहीं, डिस्चार्ज
मोरेटोरियम
ऑर्डर हो
पीरियड
जाएगा ना उसका, 6 महीने बाद डिस्चार्ज ऑर्डर हो जाएगा।
मोरेटोरियम पीरियड में तो 120 मांग ही नहीं सकता है,
मांग भी नहीं सकता, और 6 महीने में तो डिस्चार्ज ऑर्डर एडजुडिकेटिंग अथॉरिटी दे देगी, उसको कभी भी नहीं देना ये 30,000 रुपीज।
So moratorium applies to qualifying debt or all the debts?
ऑल द डेट्स।
all the dates.
ऑल द डेट्स।
तो 120 भी नहीं मांग पाएगा 6 महीना का वो।
लेकिन अभी भी इसमें गलती है, पता क्या गलती है? आप सबसे पहले शुरू में चलो, सबसे पहली वाली में क्या बोलता है? एग्रीगेट वैल्यू ऑफ दी क्वालिफाइंग डेट्स। ये क्वालिफाइंग डेट की ही बात कर रहा, पूरे टोटल डेट की बात नहीं कर रहा। तो क्वालिफाइंग डेट अगर है तो वो 35,000 से ज्यादा नहीं होने, मतलब 35,000 तक का ही डिस्चार्ज ऑर्डर हो सकता है, सिंपल सी बात है।
तो 30,000 इसका है।
हाँ, इसका 30,000 है तो हो जाएगा।
And before issue of discharge order, she should not have taken up the job.
क्यों ले सकती है, ऐसा क्या है?
जॉब तो ले सकती है, जॉब में क्या है?
Her income will become more and she will not be eligible.
नहीं, अगर वो ऐसा है भाई, इनकम में भी तो ये है ना, ये क्या बोलता है, एनुअल इनकम बोल रहा है वो।
Annual income 60,000.
If annual income exceeds 60,000, he will be
भाई अगर
month
अगर
he is
मान लो
earning
he will be
भाई,
25,000.
disqualified.
एक आदमी का मार्च में ही जॉब लगा, अब उसका इनकम ही 25,000 है, तो एनुअल इनकम उसका 25,000 ही मानोगे ना आप?
नहीं सर, एक लेकिन एक सेक्शन में आएगा
और क्लास चलছে একটা অনলাইনে। हाँ,
फाइनेंशियल कंडीशन चेंज होता है वो प्रोविजन बाद में उसको इंफॉर्मेशन देना है।
हाँ वो तो है ही, वो तो है ही।
तो मान लीजिए तो अब केस चलते चलते 4 महीना हो गया,
हाँ बिल्कुल बिल्कुल हो जाएगा,
4,000
बिल्कुल हो
ऊपर आ
जाएगा।
जाएगा इसका।
हाँ
And
पर
sir,
चलो
the-
मोटा मोटा देखो अंडरस्टैंडिंग तो डेवलप हो गया ना।
हाँ जी
Correct,
जी, असली काम माने वो केस बहुत अच्छा है ये रियली।
अब बाकी आपको अभी एक दो क्वेश्चन और पूछते हैं अभी। ये जो कॉन्सेप्ट ऑफ एक्सक्लूडेड एसेट्स है ये एप्लीकेबल होगा या नहीं होगा? देखो एक्सक्लूडेड एसेट वाला कॉन्सेप्ट तो एप्लीकेबल होगा ही होगा। क्यों एप्लीकेबल
नहीं।
होगा? क्योंकि वो तो पहले सेक्शन में दे दिया ना, डेफिनेशन सेक्शन में दे दिया। एक्सक्लूडेड एसेट्स वाला जो कॉन्सेप्ट है वो
हाँ,
आपको
जो ऑर्नामेंट है चाहे
बस लेकिन
कार
सर
है।
उसमें वो ड्वेलिंग हाउस वाला एक वो मैच नहीं हो रहा है ना।
हाँ ड्वेलिंग हाउस वाला देखो ये तो आपको 79 में ही दे दिया ना इन्होंने। सिर्फ वो ड्वेलिंग हाउस में थोड़ा चेंज है। ड्वेलिंग हाउस में ये है, यहाँ पर क्या बोलता है, यहाँ पर बोलता है कि वेदर और नॉट इट इज एनकम्बर्ड, इसमें ये बोलता है।
तो खैर यहाँ लोन पर तो है नहीं ना, लोन पर तो है भी नहीं है, डिस्प्यूट में है। यह तो क्राइटेरिया प्रॉब्लम में है तो फिर आएगा ही सर।
और ये जो एक्सक्लूडेड है, ये जितने भी डेफिनेशंस हैं जो हमारी 79 में है ये तो पूरे उस पर अप्लाई होगी ना।
सर अगर उस एग्जाम्पल में वो मैरिज नहीं होता ज्वेलरी के लिए तब वो तभी भी वो एक्सक्लूडेड होता।
भाई देखिए वो क्या लिखता है, वो लिखता है विच कैन नॉट बी पार्टेड विद ड्यू टू रिलीजियस यूसेज।
अगर नॉर्मल ज्वेलरी होती तब तो वो एक्सक्लूडेड नहीं होते ना।
हाँ फिर नहीं होती। इसमें क्या बोलता है, एनी अनएनकम्बर्ड पर्सनल ऑर्नामेंट्स of such value as may be prescribed of the debtor or his immediate family which cannot be parted with in accordance with religious usage। बस ये लिखा है इसमें।
Supposing jewelry is worth 2 lakhs, 1 lakhs will be excluded, another 1 lakh will be taken. How is that, sir? How it is dealt? Or entire 2 lakhs is taken?
भाई मेरे हिसाब से तो पूरे का पूरा ही ले लिया जाएगा फिर उसमें। ऑफ सच वैल्यू एज में बी प्रेस्क्राइब्ड, एज में प्रेस्क्राइब्ड तो यू कैन टेक 2 व्यूज, इसमें 2 व्यूज हो सकते हैं। बहुत सारे लोग ऐसा बोलते हैं कि भाई इस तरह से होगा। अभी क्या है, अभी ये कोई केस तो आने शुरू नहीं हुए फ्रेश स्टार्ट वगैरह में ना। इसका तो रूल्स रेगुलेशंस वगैरह बहुत नहीं आया ना अभी, अभी कोई फ्रेश स्टार्ट में केसेस नहीं आ रहे हैं। हाँ तो जैसा इंटरप्रिटेशन होगा, बट अभी सेफली यू कैन प्रिज्यूम, ठीक है कि भाई 1 लाख, if 2 lakhs is the value then up to 1 lakh is exempt।
1 lakh is excluded.
अब इसमें दूसरा पॉइंट देखिए, एनी एन अनकम्बर्ड सिंगल ड्वेलिंग यूनिट ओन्ड बाय द डेटर ऑफ सच वैल्यू एज मे बी प्रेस्क्राइब्ड। ऑफ सच वैल्यू किसकी बात कर रहा है? ड्वेलिंग यूनिट की। इसका मतलब ये है कि ड्वेलिंग यूनिट को तो पार्ट नहीं करोगे ना। सपोज देयर इज ए हाउस वर्थ ₹50 lakhs, तो ऐसा नहीं करोगे आपके 20 lakhs को एक्सक्लूड कर दोगे, 30 को शामिल कर लोगे, ऐसा नहीं होगा ना। क्योंकि क्या बोल रहा है, एनी अनएनकम्बर्ड सिंगल ड्वेलिंग यूनिट ऑफ सच वैल्यू, तो सच वैल्यू किसके साथ आप पढ़ रहे हो? एन अनकम्बर्ड सिंगल ड्वेलिंग यूनिट के साथ में। तो या तो पूरा ही आएगा या पूरा एग्जम्प्ट होगा, ऐसा नहीं हो सकता ना आधा हो जाए आधा ही नहीं। अकॉर्डिंगली इट इज इंटरप्रिटेशन इशू। चलिए थोड़ा सा क्वेश्चन और पूछ लेते हैं आपसे, अभी क्या समझ में आया उसके लिए क्वेश्चन पूछते हैं कुछ। इसको तो बंद करते हैं रामायण को।
सर एक्सक्लूडेड एसेट्स को का एप्लीकेशन कहाँ पे है?